Hello everyone, welcome to Unacademy's YouTube channel. Let me check if the stream is coming up in YouTube or not. After that, we will start with the class right away. Alright? Okay, the stream is coming up everyone. Let's start with today's class. Now in today's class, we are going to look at some important current affairs topics that are very important for the mains examination. Now these topics are not only important for the upcoming mains examination, they are also important for the next year's prelims examination as well. So these are the topics that we are going to look today. Now moving on, before going on to the topic itself, let me give you a brief introduction about myself as well as about Unacademy. See, my name is Aravind. I've completed my BE Mechanical Engineering in 2014 and I have almost 3 years of experience in teaching UPSC Civil Services, and I've experienced all stages of UPSC Civil Services, that is prelims, mains and then interview. Now my specialization subjects include polity, international relations as well as current affairs. Now if you want to ask doubts regarding my classes, please join this Telegram group. And here in this Telegram group, I will also regularly update the schedule of my classes as well. So please guys do join this Telegram group. Okay. Now moving on, what will you get by subscribing to Unacademy? See, by subscribing to Unacademy, one, you will get access to daily live classes. Now in these daily live classes, you get to watch your live classes, and then you can rewatch your live classes, and then if you have any doubts, you can ask those doubts if you like. Now this rewatchability feature is very very important. Why? Because if you are preparing for any competitive examination, you will feel the need to rewatch your old classes, mainly for revision purposes or for doubt clearing purposes. With any other institution, you will not have that feature, but with Unacademy, you can revisit your old classes. And then with Unacademy, they conduct live tests as well as quizzes almost on a daily basis. As you all might have known, when it comes to UPSC preparation, 50% of UPSC preparation is about practice, not preparation, and 50% is about practice. So practice is as important as preparation itself. Okay. So this practice part will come via live tests and quizzes conducted by Unacademy. And then all courses conducted by Unacademy are structured courses. They will have a proper lesson flow from A to B to C. Okay, so that the lesson flow will be much more in tune towards examination syllabus, and then the learning process also will become much easier for the student concerned. Now with Unacademy, you will get unlimited access to videos concerned with the examination that you are subscribing for. For instance, if you are subscribing for UPSC examination, you will get unlimited access to videos concerned with UPSC examination. Now I suggest you guys download this Unacademy learning app. Now via Unacademy learning app, you can keep track of your learning goals, how much time you are spending with Unacademy. All these things can be kept a better track with Unacademy learning app. Not only that, if your favorite teacher is supposed to take a class via Unacademy platform, you will get immediate notifications via Unacademy learning app. Now, the major advantage with Unacademy is there are around more than 100 top educators with Unacademy teaching UPSC. Okay. If you're not satisfied with one faculty, say for example, if you are learning quality from faculty A, you can immediately switch over to another faculty B. So that's a choice Unacademy provides you with. Now these are the charges that Unacademy charges you with for each month of plus subscription. Okay. On top of very paltry sum that Unacademy is charging you, if you're using my code Aravind V, you get 10% as offer. So instead of paying 49,500 rupees, you'll be required to pay only 44,550 rupees only. So guys, please don't hesitate to use my code Aravind V in case you are planning to subscribe for Unacademy. Now even with Iconic platform, where you get access to personal push, daily mains question and answer practice, study planner, personalized feedback, even here you can use my code Aravind V. If you're using my code Aravind V, you get 10% as offer even with Iconic platform as well. Okay, now recently Unacademy has introduced 18 plus optional courses. Okay, even for optional courses you can use my code Aravind V. Okay, so you can get 10% as offer. Okay, so that's introduction and promotion done with everyone. So let's move on to today's class. Okay, give me a moment here. Now in today's class, these are the topics that we will be looking today. Okay, Supreme Court, the number of judges in Supreme Court has been increased. The next one is we will look at pardoning powers of the president. Okay, next we will look at the curative petition, that is Article 137. What is the need for having curative petition, and what is the procedure? What is the procedure for applying for curative petition? All these things we will look in this video. And then next topic we will look is public credit registry. Now this is very important from economics perspective. Next we will look at center state disputes and the issue of Article 131. Okay, so what is the link between Article 131 and then the issue of center state disputes? And we will look at merger under 10th schedule of Indian Constitution, and then we will look at World Hepatitis Day, and then lastly we will look at the International Thermonuclear Experimental Reactor Assembly. Okay, so all these videos, for all these videos we will have a in-depth analysis. We will have a in-depth analysis. Now the reason why we are having in-depth analysis is that, see, you are learning so much of information daily for UPSC examination. Now if you want to remember all this information, you have to know why this issue is coming up and what are the reasons why this issue is happening. Okay, so you have to know what are the advantages and disadvantages, everything. Okay, you need to have a 360-degree understanding of a particular issue. Only then, okay, you can remember that information or recording regarding that particular issue. If you are just mugging up from what to say, monthly compilation or from newspapers, you won't remember a thing. For current affairs, every issue you have to analyze in depth. Why is this issue happening and what are the remedies for this issue? Okay, so in our classes, in all our current affairs classes, we will have an in-depth analysis on each current affairs issue. Now moving on to our first topic. Okay, now recently the strength of Supreme Court judges have been increased. Okay, now in this topic we will look at why there is a need to increase Supreme Court strength, and then we will look at what is the procedure to increase strength of Supreme Court judges, and then what are the constitutional provisions regarding increasing of judges for Supreme Court. Yeah. Now Supreme Court number of Judges Act of 2019 has added 4 judges to the strength. Now it has increased the judicial strength from 31 to 34, including Chief Justice of India. Okay, so before the number of judges in Supreme Court was 30 plus 1. Now this has been increased to 34 plus 1. Okay, now according to Article 124 clause 1, according to this article, there shall be a Supreme Court of India consisting of Chief Justice until Parliament by law prescribes a larger number of not more than 7 judges. Okay, so to explain this concept further, give me a moment here. Okay. So according to this article, don't mind the heading here. It's according to Article 121. According to Article 124, Article 124 says that, Article 124 clause says that there shall be one Chief Justice of India for Supreme Court, and then there will be 7 other judges in Supreme Court. Okay, there will be one Chief Justice of India, and apart from one Chief Justice, there will be 7 other judges for this Supreme Court. Now, the number of judges, that is, these 7 judges can be increased. It can be increased by a law of Parliament. It can be increased by a law of Parliament. Okay, so now using this provision, the number of judges have been increased over number of years. Now recently in 2019, okay, Supreme Court number of judges act has been passed. Now this increased the number of judges from 31 to 35. So that's the issue here. Okay. Now, thus the strength of Supreme Court judges can be increased through a simple majority of Parliament, that is more than 50% of members present and voting each house respectively. See here, here what are we doing? We are changing the text of the Constitution. Okay, we are changing from 7 judges to 31, 34 judges. So this is changing of the Constitution. So it can also be termed as amendment of the Constitution. Now, as I had discussed in my previous classes, now there are two types of amendment. Okay, there are two types of amendment. Now the first type of amendment is done outside of Article 360. Now the next type of amendment is done under Article 368. Okay, so these are the two types of amendment. Now if an amendment is done outside of Article 368, like increasing number of judges to Supreme Court, this can be done by means of passing ordinary legislation. This can be done just by means of passing ordinary legislation. Okay, but if you want to amend our constitution under Article 368, you have to pass a constitution amendment bill. Okay, it's different from ordinary legislation. Okay, now if you look at the majority required for ordinary legislation, it's just a simple legislative process. The majority is required is simple majority, that is half the members of both the houses of the Parliament present and voting. Now for passing constitution amendment bill, you need special majority. So these are the differences. Now for increasing the number of judges in Supreme Court, just a normal ordinary legislation would suffice. There is no need to amend the constitution under Article 368. So that's what they are mentioning in this line here. Now in 2009, this was the last time the number of judges in Supreme Court was increased. In 2009 saw the last amended law to increase the strength of Supreme Court judges from 26 to 31, including Chief Justice of India. Now the Supreme Court of India came into existence on 26th of January 1950, and its first sitting was held on 28th of January 1950. Now this is an important point to note. See, however, the number of judges of High Court will be determined by the order of President as provided under Article 216. See here, now the strength of Supreme Court. See here, there is a crucial difference between strength of Supreme Court and strength of High Court. Now the strength of Supreme Court. Strength of Supreme Court, it's mentioned in the Constitution itself. It's mentioned in the Constitution itself. Okay, but the strength of High Court, it is not mentioned in the Constitution. It is not mentioned in the Constitution. Okay, so if you look at the strength of High Court, who will determine the strength of High Court? See, President, in case of High Court, President is the one who appoints judges. Who appoints judges to High Court of individual states. Okay, he appoints judges to individual High Courts. Now, President is also the authority who will determine the strength of High Court. He is also the authority who will determine strength of High Court. Now, on what basis do President determine the strength of individual High Courts? Now, there is a formula for that. Okay, this formula is not prescribed in Constitution. Okay, this law is being used to determine judges of strength of judge of High Courts. Okay, now the law is average cases in the High Court for the last 5 years. Divided by average disposal of cases per judge in that High Court, or national average of disposal of cases per judge. Okay, so whichever number is higher, that is whether if it is a national average disposal of cases or average disposal of cases in that high court, whichever is higher, they will choose that. So this is the formula based on which the strength of high court is determined. Okay, but for Supreme Court, the strength of Supreme Court is mentioned in the constitution, but it's not the case for high court. Okay, for high court, the strength of judges is determined by president, not by the constitution. Okay, so that's what you have to keep in mind here in this note. Okay, now let's take a look at appointment of Supreme Court judges. Now, according to Article 124, every Supreme Court judge shall be appointed by president by a warrant under his hand and seal after consultation with such other judges of Supreme Court and of High Court in states as president may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. So what does this Article 124 say, or what does this Article 124 say? See here, it's pretty simple. President, okay, now president will appoint. Now president in consultation with, of the aid and advice, given by Prime Minister plus Council of Ministers, he will appoint judges to Supreme Court. He will appoint judges to Supreme Court. Now, before appointing judges to Supreme Court, he has to consult the Chief Justice of Supreme Court. Okay, he will both before appointing judges for Supreme Court as well as High Court, he has to consult with the Chief Justice of Supreme Court. Now, over a period of years, now this process of consultation evolved. Okay, in various Supreme Court judges, like 2 judges case, 3 judges case, Supreme Court said that Supreme Court will form a collegium. Now this collegium will recommend judges to president, and president has to compulsorily appoint whichever names chosen by this collegium. Okay, constitution merely states that president has to consult, but this consultation role has changed because of various Supreme Court judgments. Now these Supreme Court judgments stated that Supreme Court will form a collegium. Now based on this collegium recommendations only, president can appoint Supreme Court judges. Okay, and he has to compulsorily adhere to the names given by collegium. Okay, now the other judges are appointed by president after consultation with Chief Justice of India and other judges of the Supreme Court and High Court as he deems necessary. Now the consultation with Chief Justice is obligatory in case of appointment of judge other than Chief Justice. Okay, now we will look at where is the seat of Supreme Court. Now Delhi is the seat of Supreme Court as per the constitution. Now constitution also authorizes Chief Justice of India to appoint other places or places as Supreme Court with the approval of the president. See here. Now constitution, according to Article 14, what does it guarantee? It guarantees right to equality for everyone. Now right to equality means right to fair trial as well. Okay, right to fair and equitable trial. But if you look at the seat of our Supreme Court, okay, this is Tamil Nadu. Sorry, this is India's map. Okay, now assume this is India's map. My diagram is very poor. Now Delhi is located here. Okay, now people from Punjab can easily access Supreme Court. It is a very short distance for them. But if people from Kerala or Tamil Nadu want to access Supreme Court, it is a very long distance. Okay, so this right to equality, right to access to justice is not equal for everyone because of the seating of Supreme Court. Now to address this problem, Constitution authorizes Chief Justice of India to appoint other places as a seat of Supreme Court with the approval of President. Okay, now importantly, recently there has been appeals from a number of parties to institute a new type of court called as National Court of Appeals. Okay, now this is one type of idea that is being mooted out recently. So just read about this National Court of Appeals in the newspaper. Okay, now the last provision is that no court can give any directions to either President or Chief Justice to appoint any other place as seat of Supreme Court. So only Chief Justice and President of India can determine which place to be appointed as Supreme Court seat. Okay. So this is the first topic. Okay, first topic has been finished. Now give me a moment here. Now the next topic that we will be discussing today is pardoning powers of the president. Okay, see here, now this issue was chosen because in case of death sentence to perpetrators of Nirbhaya rape case, now the pardoning powers of president was discussed. Okay, so now this Nirbhaya rape case victims, okay, now for this Nirbhaya rape case victims, the judgment has been already pronounced by the Supreme Court. Judgment has been already given. Now there are two remedies for these victims. Okay, one is curative petition. The next one is pardoning power. Pardoning power of president. Okay, so these are two avenues that are given to these Nirbhaya victims. Not only Nirbhaya rape case, Nirbhaya rape perpetrators. Okay, this is one is curative petition. These are two ways based on which they can challenge the judgment of Supreme Court. Now curative petition they can file only in Supreme Court. Now pardoning power, it is an appeal to President of India. Okay, this is an appeal to President of India. Okay, now we have to understand the fundamental differences between curative petition and pardoning powers of the president. Now this curative petition is a judicial process. It's a judicial process. This curative petition will be filed in Supreme Court, and Supreme Court will form a bench, and then they will decide whether the original judgment was correct or not. That is a judicial process. But this pardoning power is an executive process determined by President of India on the aid and advice given by Council of Ministers. Okay, so in this class we will look at both curative petition as well as pardoning powers of president. Okay, in this class we will look at both curative petition as well as pardoning powers of the president. Okay, so now this pardoning powers of the president is given under Article 72. The pardoning powers of president is given under Article 72 of Indian Constitution. Now this Article 72 tells us who is the authority who can grant pardons to individuals, and then it also discusses in what cases the pardoning powers will be used. Okay, Article 72 discusses two things. One is authority who can grant pardons to individuals, and then it also discusses in what cases these pardons are given. Now if you look at authority who grants pardons, okay, President is the authority who will grant pardons. President is the authority who will grant pardons. Now the President will grant pardons on the aid and advice of Prime Minister plus Council of Ministers. Is it clear? President will grant pardons based on aid and advice given by Prime Minister of Council of Ministers. Okay, now in what cases this president is empowered to grant pardons? One is cases which involve sentencing under central law. Cases which involve sentencing under central law. The next one is court martial. Okay, and the last one is death sentence, both by state law as well as central law. Okay, death sentence both by state law as well as of course, Ravichan, that's what we are discussing here. Okay, death sentence, president can grant pardons for death sentence both in case of state law as well as central law. Now these two pardons, court martial as well as pardoning powers in case of death sentences, these are exclusive powers of President of India. These are exclusive powers of President of India. These are not given to Governor of State. Governor can grant pardons only in case of sentencing under state law. He cannot grant pardons even if the case is death sentence under state law. Death sentence pardon can be given only by President of India and by no other authority. Is it clear, everyone? Now we will move on to the next part. Okay. Now we will move on to the next part. Okay. There are different types of pardons in Constitution of India. There are different types of pardons. Okay. Now those different types of pardons include pardon, commutation, remission, respite, and then reprieve. Okay, so these are different types of pardons that can be given by President of India. So you have to understand what are the difference between these types of pardons. Okay, there are differences between these individual pardons. Okay, now if President is granting pardon, what happens is that if President is granting pardons, no sentence is given. That is, what is the meaning of no sentence is given? It completely absolves the person. It completely absolves the person of any crime. Okay, it completely absolves the person of any crime. So if President is granting pardon, the next day itself this person can walk free from the jail system. Now in case of commutation, what happens is that the nature of the sentence is changed. Nature of the sentence is changed. Now what is the meaning of nature of sentence being changed? So there are different types of sentences that have to be granted. Okay, one is rigorous imprisonment, simple imprisonment, solitary confinement. So there are different types of imprisonments granted to different individuals based on their crime, based on their threat level. Okay, so in case of commutation, the term of sentence will not be changed, but the nature of sentence will be changed. So if President is granting commutation, 10 years of rigorous imprisonment will be changed to 10 years of simple imprisonment. Okay, so the nature of imprisonment will change for this person, not the tenure. Okay, but in case of remission will cause change in tenure of sentence, not the nature. Okay, it's the opposite of commutation. It changes the tenure. So 10 years of rigorous imprisonment will be reduced to 5 years of rigorous imprisonment. So that's what happens in remission. Now in case of respite is granted for temporary period. Respite is granted for temporary period in case of medical ailments. In case of medical ailments like pregnancy. Okay, this is a temporary suspension of sentence given in case of special emergencies. It is given in case of special circumstances like medical emergency, like pregnancy. Now in case of reprieve means postponing of sentence. Now what is this? What is the reason for having this reprieve commutation? So reprieve clemency is that. See here. Now let's assume there is a person A. Now this person A is due to be hanged in 2 days. This person A is due to be hanged in 2 days. Okay. Now in this 2 days, what this person is doing is that he is approaching president, and is asking for clemency from president. He is asking for clemency from the president. Now president obviously needs some time to take his decision, right? Okay, he needs some time to take his decision. So what he will do is that he will use his reprieve clemency power. He will use his reprieve remission clemency power to postpone this hanging to later on date. He will use his reprieve clemency to postpone this hanging to later date so that he can take his decision on death sentence. So death reprieve clemency power is usually used in case of death sentences by the President of India. Okay everyone, so this is the different types of pardoning powers given by a President of India. Now importantly, see here, now as I mentioned before, if president grants clemency, if president grants clemency to an individual A, if presidency grants clemency to individual A, this clemency is one, according to constitution, it's an executive power of the president. It's an executive power of the president. It's not a judicial power. What is the meaning of executive power? Okay, it's not done by means of judicial means. Okay, so there won't be judicial committee which inquires all these things. It's an executive power. They will decide whether to grant clemency or not. Based on that, they will decide whether or not to grant clemency. Okay, and this clemency cannot be challenged in Supreme Court. Cannot be challenged in Supreme Court. Okay, now this clemency cannot be challenged in Supreme Court according to Constitution. So this clemency power of President according to Constitution is an executive power, as well as it cannot be challenged in Supreme Court. But Supreme Court, in Epuru Sudhagar case, has said that the clemency power of Supreme Court can be challenged in Supreme Court. It can be challenged in Supreme Court for violation of natural justice. So if president is not following the protocol set by the Constitution, it can be challenged in Supreme Court. So for example, if president is taking undue amount of time to grant his clemency, in that case the natural justice of the prisoner will be violated. In that case, the prisoner can challenge this clemency power of president in Supreme Court. Is it clear? So this thing you have to keep in mind here. We will move on. So we have discussed everything about pardoning powers of the president. Okay, we have discussed everything about pardoning powers of the president. Okay, now as I discussed earlier, okay, now in case of Nirbhaya perpetrators, okay, the judgment has already been given. To hang these individuals. Okay, now this judgment can be challenged in two ways. One is via curative petition, another one is via pardoning powers of the president. Okay, now in this so far we have discussed the pardoning powers of the president. Now in our next topic we will discuss what is the curative power of the Supreme Court of India. Okay, what is this curative power of Supreme Court of India? See here, now this curative petition. Okay, now this curative petition is that curative petitions were filed in Supreme Court by two convicts in the Nirbhaya case recently, after their review of petition was rejected by Supreme Court and mercy petition rejected by the President of India. Now what is this curative petition? See, the concept of curative petition was first evolved by Supreme Court of India in Rupa Ashok Hura versus Ashok Hura and another case on the question whether an aggrieved person is entitled to any relief against the final judgment or order of Supreme Court even after the dismissal of review petition. Okay, now what are the objectives of curative petition? The objective of curative petition is twofold. One is avoid miscarriage of justice, and next one is to prevent abuse of process. Okay, now I'll give you an example. See here, now this person A is convicted to death sentence. Okay, by Supreme Court. He is convicted to death sentence by Supreme. Not it can, death sentence. Okay, originally it cannot come to Supreme Court. Okay, this a person A has been convicted of death sentence by District Court. Okay, now this death sentence given by District Court is confirmed by Supreme Court by means of appeals. Okay, now after awarding of this death sentence, new evidence is coming into light saying that this person A did not commit this crime. Okay, new evidence is coming into life saying that this person A did not commit this crime, another person committed this crime. Okay, now based on this new evidence, Supreme Court has to revise their judgment, right? Supreme Court has to revise their judgment. If they are not revising the judgment, what will happen? It will be gross miscarriage of justice itself, because this person is being wrongly convicted of crime he did not commit. So for these purposes, curative petition is there. So the objective is twofold. One is to avoid miscarriage of justice, and the next one is to prevent abuse of the process. Now, what is the constitutional background on curative petition? See, the concept of curative petition is supported by Article 137. It is supported by Article 137 of Indian Constitution. Now, this Article 137 provides that in the matter of laws and rules made under Article 145, the Supreme Court has the power to review any judgment pronounced or order made by it, and such a petition needs to be filed within 30 days from the date of judgment or order. Is it clear? Any review petition has to be filed within 30 days from the date of judgment or order. Now, what is the procedure for filing this curative petition? Now, this curative petition may be filed after a review plea against the final conviction is dismissed. Okay, so after the final conviction, after the final verdict is given, what will happen is that these individuals will file review. They can file review petition. Okay, even after this review petition has been rejected, they can file curative petition. Now, but the process of filing review petition, curative petition is a lot more different, and the process of filing curative petition is a lot more stringent process as well. Now, curative petitions can be entertained if the petitioner establishes that there were violation of principles of natural justice and that he has not been heard by the court before passing an order. Okay, so if the petitioner can establish that the principles of natural justice was not followed by Supreme Court of India when passing the order, he can file this petition by citing violation of principles of natural justice. Now, this curative petition must be a rare process rather than a regular process. Now, a curative petition must be circulated to a bench of 3 senior most judges, and the judges who pass the concerned judgment, if available, only when a majority of judges conclude that the matter needs hearing should it be listed before the same judge. So before this petition going into Supreme Court, what will happen is that before this is a curative petition. Okay. Both review of judgments as well as orders can be reviewed by means of curative petition. Now, if there is a curative petition, this curative petition, before being applied to Supreme Court, before being admitted into Supreme Court, what should happen is that before being admitted into Supreme Court is this curative petition has to be supported by senior lawyers of Supreme Court plus the original bench who gave this verdict. Okay, and if they conclude that this matter requires the due process of Supreme Court, then the curative petition will be admitted into Supreme Court. Now, the bench at any stage of consideration of the curative petition can ask the senior counsel to assist it as amicus curiae, that is friend of court. Now, a curative petition is usually decided by judges in the chamber unless specific request for an open court is being allowed. Okay. Now, what are the grounds for rejection of curative petition? Now, in the event of bench holding at any stage that the petition is without any merit, it may impose a penalty on the petitioner. So, if a curative petition is filed based on frivolous grounds, a Supreme Court is entitled to impose penalty on the petitioner. Okay, so these are the things regarding, these are some of the information regarding curative petition. Okay, now so do you have any doubts, people? So far we have discussed two ways to review a judgment given by Supreme Court. One way to review is by means of pardoning powers of the president, and another one is by means of curative petition. Now recently both these methods have been exercised by Nirbhaya rape case perpetrators. Okay, so if you have any doubts so far, please ask right now in the live chat section. Okay, and I will try to answer those. I will give you 1 minute to ask your doubts so far. After that I will move on to the next topic. If you have any doubts so far, people, please ask in the live chat session. Or do you want me to repeat both these things again? I will explain these things again if you want to. Okay, since no one is asking any doubts, I will move on to the next topic of today. Now the next topic that we are going to discuss today deals with center state disputes and Article 131. Okay, now we are discussing this article because recently Kerala became the first state to challenge the Citizenship Amendment Act before Supreme Court under Article 131 of the Constitution. Okay, now we have to discuss what is this Article 131. Okay, now we have to discuss this, what is this Article 131 in detail. See, Article 131 talks about, it talks about the original jurisdiction of Supreme Court. It talks about the original jurisdiction of Supreme Court. Now, what is the original jurisdiction of Supreme Court? It involves dispute between central government and state government, between state government and state government, and between central government and versus two or more state government. Okay, so the original jurisdiction of Supreme Court includes dispute between central government and state government versus central government and two or more state governments. Okay, now what is the meaning of original jurisdiction? What is the meaning of original jurisdiction? In the name itself is that this case, if a case is under original jurisdiction, that case has to freshly originate in Supreme Court. Is it clear, everyone? If a case is termed as original jurisdiction, that case has to freshly originate in Supreme Court. Is it clear? So for the first time itself, if there is a dispute between central government and state government, for the first time itself, it can be for first time as well as freshly it can be filed in Supreme Court even before filing in any other court. That's the meaning of original jurisdiction. Now this Article 131, it's not only original jurisdiction, it's also an exclusive jurisdiction. It's also an exclusive jurisdiction. Okay, and then it is also a very important feature of federal feature of Indian Constitution. It is also an important feature of federal provision in Indian Constitution. So we will discuss why this is very important, why this is one of the important feature of federal feature of Indian Constitution. After that we will discuss why it is an exclusive jurisdiction of Supreme Court as well. See here, what is federal country? What is a federal country? A country which has two or more levels of government. A country which has two or more levels of government. Two or more levels of government is called as federal country. So there will be, in a federal country, what will be there? There will be a central government, and there is a state government. Okay, so in a federal country there will be a central government and then there is a state government. Okay, now even in UK there is a central government as well as state government. Even in UK there is a central government and state government, but UK is not called as unitary government. Why? Because in UK central government will come under the authority of, state government will come under the authority of central government. Okay, central government is the one which grants power to state government. They only create state government. They only will demarcate which territory will come under this respective state governments. All these things. Okay, so state government will come under central government. It is completely subservient to central government. But in case of federal government, what happens is that both central government and state government, they are independent of each other. Both central government and state government, they are independent of each other. So how can we ensure that they are independent of each other? By defining what is the sphere of state government and what is the sphere of central government. So in what area central government will have authority and in what area state government will have authority. So now this demarcation of power is done by means of a principle called as division of power. This demarcation of power is done by a principle called as division of power. Now if this division of power should be guaranteed by a constitution. Okay, this division of power should be guaranteed by a written constitution. What is the meaning of guaranteed by written constitution? Imagine if there is no written constitution and this division of power was granted by parliament. What will happen? Parliament can immediately take away this division of power if they feel that state government is having too much power. Okay, so in that case, can we call India as a true federal country? No, right? So that's why any federal country should have division of power guaranteed by written constitution. Now, even though we have clearly demarcated the powers between central government and state government, now at times there will be a dispute between central government as well as state government. At times there will be a dispute between central government and state government. Now, during the times of this dispute has to be settled by an independent. It has to be settled by an independent judiciary. Now, this independent judiciary in India is Supreme Court. Independent judiciary in India is Supreme Court. Okay. So that's why this Supreme Court, this original jurisdiction to decide dispute between federal units is an important federal feature of Indian Constitution, and this feature is an exclusive jurisdiction of Supreme Court. Now, why is this only exclusive jurisdiction of Supreme Court? Why not High Court? See here, if you look at High Court, if assume this is India, okay, assume this is India. Now I know my diagram is very terrible, okay. Assume this is India. Now there is a dispute between Tamil Nadu and Kerala. There is a dispute between Tamil Nadu and Kerala. Okay. Now this is a federal unit dispute. Okay. There is a dispute between two federal units. Now, according to Article 131, this dispute can be filed only in Supreme Court. Why not in High Court? See here, if why not in High Court of Chennai? Why not this case cannot be filed in High Court of Chennai? See here, what is the territorial jurisdiction of High Court of Tamil Nadu? High Court superintendence applies only to the state of Tamil Nadu as well as Puducherry. High Court superintendence applies only to Tamil Nadu and Puducherry. It doesn't apply to Kerala. Is it clear? The power of High Court in Chennai applies only to the state of Tamil Nadu as well as Puducherry. It doesn't apply to Kerala. So any judgment given by High Court of Chennai will not apply to Kerala government. Okay, so that's why, since High Court doesn't have the power to enforce its rules to Kerala, so that's why if there is a federal dispute, it's an exclusive jurisdiction of Supreme Court, not for High Court. Is it clear, everyone? Is it clear? But there is another original jurisdiction of Supreme Court called as writ jurisdiction. Okay, there is another original jurisdiction of Supreme Court called as writ jurisdiction. Now, this writ jurisdiction will be filed in case of violation of fundamental rights. Okay, now this writ jurisdiction is exercised both by Supreme Court as well as High Court. Unlike federal disputes, this writ jurisdiction is exercised both by Supreme Court as well as High Court. Okay, so that's background information on Article 131. Okay, so Article 131 is the original and exclusive jurisdiction of Supreme Court when it is looking at the disputes which rises between union versus state, state versus states, union and state versus state of states. Okay, and what is the need for Article 131? See, in Indian Constitution, Supreme Court has mentioned as the guardian of fundamental rights guaranteed to us under Article 13. Thus, for any kind of violation of fundamental rights, we have to directly go to court under Article 32 of Constitution. But when there is a dispute arises between states of India or between the state government and the union government, then it is the jurisdiction of Supreme Court under Article 131 of the Constitution that gives the power to resolve these kinds of disputes. Okay, so if there is a dispute in fundamental rights, if there is a problem in fundamental rights, a person can approach Supreme Court or High Court. But if there is a dispute between federal units, it's a dispute between federal units, there is only one court where states can approach. That court is Supreme Court. Why? Because Supreme Court has been given these powers under Article 131. Now Article 132 gives the Supreme Court original jurisdiction but not exclusive jurisdiction. Okay, as I mentioned before, it's not an exclusive jurisdiction because the reason that even High Courts have the jurisdiction under Article 226 of Indian Constitution. It is only Article 131 that gives the court original and exclusive jurisdiction, as it can solve disputes which arises out of President and Vice President election. Okay, now we say that a court enjoys original jurisdiction when it has got authority to hear the case in its first instance, but when we say that it also enjoys exclusive jurisdiction, it means that the whole and sole authority to hear and determine the case, and no other court has the power. Okay, and no High Court has such original jurisdiction on federal disputes. Okay. Now, what are the requirements for invoking Article 131? Now, the parties to the dispute for invoking Article 31 is that it must involve dispute between center and states, and center and state on the other side, and other state on the other side, and two or more states. Okay, and then it cannot be used to resolve disputes which involves private party and government on the other side. So, if it is a dispute between Government of India and private individual, it cannot be resolved by Supreme Court of India. It can be resolved only by lower courts. Okay. Now, what are the subject matters that can be resolved under Article 131? See, these subject matters must involve a question of law or a fact on which existence of legal right of state or center depends. Okay, and then it cannot be used to settle political differences. It can be used to only settle constitutional as well as constitutional and legal differences, not for political differences. So if BJP and Congress is having a fight, Supreme Court cannot be used as an arena to settle their disputes. Now, what are the exceptions under Article 131? What are the exceptions under Article 131? Now, jurisdiction under Article 131 does not extend to dispute arising out of any treaty, agreement, covenant, engagement, sand or other instruments in India which was entered before the commencement of Constitution, which continues in operation after the commencement of Constitution. If such dispute arises, it is the exclusive domain of the executive. Is it clear, everyone? See here, it is clearly mentioned that, see here, even before Constitution, even before 1950, British India, they entered into various agreements with princely states. They entered into various agreements into princely states as well as other provinces. Okay, they entered into other provinces. For example, I will give you Mullai Periyar Dam. Okay. Now, the sharing of Mullai Periyar Dam water between the state of Kerala as well as Tamil Nadu was this dispute was settled in, the agreement was signed even before the commencement of the Constitution. Okay, but if Supreme Court wants to try this dispute of Mullai Periyar based on the agreement which was signed before 1950, Supreme Court cannot decide on those matters. Supreme Court cannot give judgments on that matter. Only executive has the power regarding these matters. Only executive has the power regarding these matters. What is the meaning of executive? Only President has the power to award judgments on this matter. Not judgments, President has the power to resolve these matters. No, not Supreme Court. Is it clear, everyone? Only President has the power to resolve these matters, not Supreme Court. Now, Supreme Court can give judgments regarding these pre-constitutional treaties in another jurisdiction. I will explain this now. Okay. See here. So, with regards to pre-constitutional treaties, this case can be heard by Supreme Court under advisory jurisdiction. Okay, these pre-constitutional treaties can be heard by Supreme Court under advisory jurisdiction. See, under Article 143, under Article 143, and Article 143 talks about advisory jurisdiction. It talks about advisory jurisdiction. Now, there are two types of advisory jurisdiction. Okay, one is under clause 1, another one is under clause 2. Okay, there are two types of advisory jurisdiction. One is under clause 1, another one is clause 2. So, under clause 1, if president, if he is having any doubt, he can refer any matter. He can refer any matter. He can refer any matter for the advice of Supreme Court, and Supreme Court has a choice of whether to accept this particular case from president or to reject this particular case. Is it clear, everyone? President under advisory jurisdiction can ask any doubts to Supreme Court, and Supreme Court has the power to accept this doubt or reject this doubt. But if president is asking doubts to Supreme Court regarding pre-constitutional treaty, that's what I mentioned now. What are the exceptions under Article 131? Treaties which are signed before Constitution comments. So, if there is a pre-constitutional treaty and if President is asking doubts regarding those pre-constitutional treaties, Supreme Court has to give its advice. Now, once Supreme Court has accepted President's advisory power, they will form a bench. To advise President regarding that matter, and this bench will give its verdict. Now, this verdict is not binding. On President. So, President can either accept this verdict or reject this verdict, and crucially, this verdict is not subject to judicial review. It's not subject to judicial review. Okay. So this is how these pre-constitutional treaties are being dealt in India. Okay. If there is a pre-constitutional treaty, it won't come under the original jurisdiction of Supreme Court. It will come under the domain of executive, and if executive is having any doubts regarding the application of executive, using advisory powers, they can ask Supreme Court regarding their opinion, and that is only opinion. It is not a judgment. So, okay. So that's it, everyone. So if you have any doubts in this topic, you can ask in the live chat session, and if you're not asking any doubts, I will move on to the next topic. Okay. Now I'll give you 1 minute to ask your doubts, everyone. Okay, if you're not asking your doubts, I will move on to the next topic. Okay, see, time's up, everyone. See, now next topic that we will be discussing today is public credit registry. So in this topic we will look at what is this public credit registry and what is the need of having this public credit registry. Okay, so now give me a moment here. Okay. See here, this public credit registry, it's an extensive database. It's nothing but this public credit registry. It's nothing but an extensive database of credit information that will capture information pertaining to borrowers, both individual as well as corporate, including data about willful defaulters and pending legal suits against them. So this public credit registry, so far this public credit registry will have all the information regarding borrowers. So any individual, any person who is borrowing money from bank or any authority, so whether whether it is an individual or be it a corporate, okay. So all this information, all this credit information will be stored under public credit registry. All this information will be stored under public credit registry. Now it will also include data from entities like market regulator SCBI, corporate affairs ministry, goods and service tax network, and the insolvency and bankruptcy board of India, to enable banks and financial institutions to get a 360-degree profile of existing and prospective borrowers of on a real-time basis. See here, if in India, not just in India, if a person A, he can borrow multiple times. Okay, he can borrow multiple times and he can invest this money in a share market. Okay, so if he's borrowing from banks, if this person A is borrowing from banks, now this borrowing data by this person A will be with RBI. Okay, now if the same person A is investing in share market SCBI, or if he is selling shares in SCBI, or if he's owed any amount of money to other investors, all this information is kept by SCBI. And if he's defaulting on any loan, or if he's going through a bankruptcy process, this bankruptcy detail will be kept in Insolvency and Bankruptcy Board of India. Okay, and then his GST payments. Okay, GST payments. So this GST payment will have how much transaction he has made, all these things. Now these GST payments will be kept under GST network. So so all this credit information. So this borrowing as well as spending information is scattered across various institutions. Now what this public credit registry is aiming to do is that it will pool all this information from different authorities. So that in future, if a person is asking for loan from a bank, if a person A is asking loan from a bank can have all the spending habits as well as borrowing habits of this particular individual A, so that banks can have a better overview as well as financial profile of their borrower. Now, what are the benefits of having this public credit registry? Now, credit assessment and credit pricing, this is the first advantage of having this public credit registry. Now, this will help banks to distinguish between bad as well as good borrower, and accordingly offer attractive interest rates to a good borrower and higher interest rate to bad borrowers. Is it clear, everyone? If they have access to all financial information like borrowings, the insolvency data, their spending habits, all these things, banks can better establish who is a good borrower and who is a bad borrower, and based on that information they can charge differing interest rate based on their borrowing habits. Now this public credit registry also can enable RBI in understanding whether monetary transmission is fully working or not. And it also can help banks and regulators in early intervention and effective restructuring of stressed bank credit. So even before occurring of NPS itself, authorities can determine whether this individual is going to become NPA or not. So it can be effectively used for early intervention and effective restructuring of stressed bank credits. Now the current existing credit registries in India is highly fragmented. So this credit registries is highly fragmented into three authorities. One is Credit Information Authority, credit information companies. Now these credit information companies are regulated by the RBI under Credit Information Companies Regulation Act. Example: TransUnion Civil, Equifax, Experian, CRIF, Highmark Credit Information Services. All these credit information companies are regulated by RBI under Credit Information Companies Regulation Act of 2005. Now the next credit registry is Central Repository of Information on Large Credits. Now this has a database on all borrowers entities which has an aggregate exposure of more than 5 crore rupees. If a borrower is borrowing loans for more than 5 crore rupees, all this information is stored in Credit Repository of Information on Large Credits. Now this is set up by body is set up by RBI in 2014-15. Now it captures about 60% of entire bank credit and around 80% of non-performing loans of scheduled commercial banks. Now the next one is information utility. Now this information utility stores financial information that helps to establish defaults as well as verify claims. National E-Governance Services Limited is India's first information utility regarding this matter. Okay, so this is how public credit registry operates, everyone. Okay. So that's it with regards to this topic, everyone. So if you have any doubts in this topic, you can ask in the chat section. I'll give you 1 minute to ask your doubts. If you're not asking any doubts, I will move on to the next topic. If you have any doubts so far, please ask people. If you're not asking any doubts, I will give you 1 to 2 minutes to ask your doubts. And if you're not asking any doubts, I will move on to the next topic. Next topic is merger under 10th schedule. Merger under 10th schedule. Okay. Thank you, everyone. See here. Now, before discussing merger, okay, excuse me. Now, before discussing merger, okay, now we have to discuss what is anti-defection law. We have to discuss what is anti-defection law. See, anti-defection law is one way where an MP or MLA is being disqualified. Okay, where an MP or MLA is being disqualified. Now, if you look at ways based on which an MP is disqualified, MP is disqualified based on Article 102. An MP is disqualified based on Article 102. Now, there are 3 ways based on which an MP can be disqualified under Article 102. Those 3 ways include: 1, based on provisions in Article 102 itself, based on provision in Article 102 itself. Okay, the next one is based on law passed by the Parliament, and the next one is anti-defection law. The next one is anti-defection law. So here, see here, if you look at the provisions mentioned in Article 102 itself, provisions like if a person is of mentally unsound mind, if he is declared insolvent by a court of India, if he is declared as insolvent. What is the meaning of declared insolvent? Meaning that this person owes some amount of money to Government of India or banks, and he has to be declared by a court of India. And then next one is if he is holding office of profit. Next one is if he ceases to be citizen of India. So all these provisions are mentioned in Article 102 itself. Now, if you look at based on law passed by the Parliament, one example is Representation of People Act 1951. So this is one law passed by the Parliament which decides on disqualification of MPs under Article 102. See now regarding these two matters, the authority who can disqualify MPs is President. Okay, the authority who can disqualify MPs is President on the aid and advice of Election Commission of India. Okay, sorry, not aid and advice. On the advice of Election Commission of India, President will disqualify these individuals for provisions under Article 1 or 2 as well as based on law passed by the Parliament. But if you look at anti-defection law, now this anti-defection law was not originally given in the Constitution. It was not originally here. It's not an original provision of Constitution. Okay. Now this was added. This was added by 52nd. It was added by 52nd Constitution Amendment Act. It was this anti-defection law was added by 52nd Constitution Amendment Act. Now this anti-defection law added 10th schedule. Okay, this anti-defection law added 10th schedule. Now this 10th schedule will include provisions based on which, okay, it will include provisions based on which a person can be disqualified. Is it clear, everyone? This anti-defection law was not original provision of the Constitution. It was added by 52nd Constitution Amendment Act. Now this anti-defection law has introduced a 10th schedule. This 10th schedule will have instances where an MP or MLA can be disqualified by Speaker. Okay, they can be disqualified by Speaker of respective houses. Okay, this is very important. See here, in case of law under Article 1 or 2 as well as law passed based on law passed by the Parliament, in these instances this disqualification is decided by President of India on the advice of Election Commission of India. But for anti-defection law alone, the authority who can disqualify members is Speaker of respective houses. Okay, if in Lok Sabha this person MPs can be disqualified, will be disqualified by Speaker. In Rajya Sabha, these MPs will be disqualified by Chairman of Rajya Sabha. In State Legislative Assembly, MLAs will be disqualified by Speaker of State Legislative Assembly respectively. Is clear? Now, what is the reason? What is the reason why anti-defection law was introduced in Constitution of India? What is the reason why anti-defection law was inserted in Constitution of India? See, in 1970s, what happened is that number of MPs. This was a time where corruption was very rampant. Number of MPs as well as MLAs, they moved from one party to another party because of money as well as horse trading. They moved from one party to another party. Now this is a gross violation of parliamentary principles. Why? Because if a person A, okay, if person A is moving from BJP to Congress, if he is moving from BJP to Congress, okay, now before 1985 there was no provision to disqualify this person. There was no provision to disqualify this MP A. Now since there was no provision to disqualify this person, now parties, they resorted to horse trading. So using money, what they did was that to secure majority, they will pay this MLA as well as MP to move from one party to another party. Now what will happen? Now this person A will come to, people will vote for this person A based on promises given by BJP party, not based on promises given by Congress party. Is it clear? This person A, he is going to MP as well as MLA position based on promises given by BJP government, not based on Congress government. Okay, so if he is moving from BJP to Congress, it is amounting to deception of his constituents. He is cheating his constituents, right? Because that's not the platform he fought on. And not only that, because of this horse trading, number of governments were becoming increasingly unstable. Okay, if more number of people, okay, for example, in elections, BJP got majority. Now, because of horse trading, number of MLAs moved from BJP to Congress. Now, as a result of this horse trading, BJP lost its majority. So, it became, governments of state governments became very unstable because of this horse trading. So to put an end to this defection of persons from one party to another party, anti-defection law was introduced by 52nd Constitution Amendment Act. Okay. So according to this anti-defection law, if a person A moves from one party. If a person here moves from one party to another party, this person will be disqualified. This person will be disqualified. But if enough members of party 1 move from party 1 to party 2, okay, if enough members move from party 1 to party 2, this will be considered as merger. This will be considered as merger. Now, what is the threshold? What is the threshold for enough members? Now, originally the threshold was 1/3 members of one party. Originally under 52nd Constitution Amendment Act, the original threshold was 1/3 of members, but it was later changed to 2/3 members. Only if 2/3 members defected from one political party to another political party, it will be considered as merger. Okay. Now we will discuss in detail what is the recent issue under merger under 10th schedule. See here, now recently in Bahujan Samajwadi Party, it has issued a whip in Rajasthan Assembly and has asked all 6 members of legislative assemblies to vote against Indian National Congress government on floor test. Okay. Now, however, all 6 BSP MLAs have joined Indian National Congress, announcing merger in September of 2019. Okay. So now here, see here, BSP is a national party. Okay. Now, but if you look at these MLAs are from are a part of state wing of BSP. Okay. So the original parent party is BSP in national level, but these MLAs are a part of BSP in state wing. Okay, so this is a curious case. Okay, this is a very curious case because without the permission of, without the actual merger of all BSP members in national level, how can we accept this merger of BSP MLAs in state level? So that's the issue here. Now, what are the key points regarding this merger? Now, BSP is arguing that state unit of a national party cannot be merged with the party being merged at national level. So, without the party being merged at national level, so that without 2/3 of members at national level being merged with the Congress, state level party of BSP cannot merge with state level Congress. It has termed the merger of 6 MLAs as illegal and unconstitutional. Now, it has cited 2 decisions of Supreme Court to support the arguments of BSP party. Now, what are the 2 decisions of Supreme Court? Now, those 2 decisions include Jagjit Singh versus State of Haryana in 2006. Now, in this case, 4 legislators from a single member of Haryana Assembly who said their parties had split and later joined Congress. Now, the court upheld speaker decisions disqualifying them. Okay. Now, also in Rajendra Singh Rana and Os versus Swami Prasad Maurya in 2007 case. Now, in 2002, Uttar Pradesh elections, 37 MLAs, 1/3 of BSP strength, split from the party after its government fell to support Samajwadi Party. Now, SC ruled that split cannot be recognized primarily because not all these MLAs split at once. So, they split at different times. So, because they split at different times, okay, so it cannot be considered as split of political party. Now, it can be noted that the above 2 cases were prior to 91st Constitution Amendment Act of 2003, which deleted the paragraph 3 of 10th schedule. Now, this amendment was made as the 1/3 split rule was grossly being misused by parties to engineer divisions and indulge in horse trading. Now, 1/3 was regarded as an easy target to achieve, and the law now exempts defection only in case of 2/3 defection. So, only then the merger will be accepted by Speaker of a particular assembly. Now, what are the opinions of constitutional experts on merger? See, according to PDT Achari, merger under 10th schedule anti-defection law can take place only between 2 original political parties. Okay, so only if national party under BSP Okay, we only if BSP at national level is merging with BJP is acceptable. Political merger at state level should not be encouraged. Now there are two conditions that need to be fulfilled for a merger under 10th schedule. There should be a merger of political parties between the original political parties, not units. Subsequently, two-thirds members of that house belonging to that party should accept the merger. If two-thirds of members do not accept it, then the merger doesn't have to happen as per the law. Now, according to Achari, the anti-defection law basically aims at protecting the party system, not just at curbing defection. Subhash Kashyap has written number of wonderful books regarding the functioning of central government, especially a book like Our Parliament. Okay, this is very good book. Okay, it discusses in detail regarding how our parliament works and what are the provisions for passing individual bills, all these things. Now, my I take classes regarding based on the information given in Our Parliament book only. It's a very wonderful book. Even a layman can read this book. Okay, so I suggest please read this book, Our Parliament, book written by Subhash Kashyap. Now, Subhash Kashyap has also agreed with PDT Achari by saying that for a merger to happen, the party which sets up the candidates for the election is a party who has to merge under 10th schedule, and one of the requirements for this is two-thirds of MLAs of that party should agree for that merger. However, Faiz and Mustafa disagreed with above position and questioned the concept of merger between two original parties. According to him, this would mean that legislative party will not have any right to merge with anybody in any state. Okay, so sorry for that. Now he referred to the definition of legislative party under 10th schedule, which defined as a group constituting of all members of that house. Yeah, so according to him, the merger has to be seen locally or not at national level. Mustafa also pointed out that nowhere does 10th schedule talk about how a national party should split or a regional party should split. Now, what are the similar previous cases regarding this merger? See, in June 2019, the Vice President issued orders to merge Telugu Desam Party, which the ruling BJP in Rajya Sabha after four TDP MLAs of five defected to BJP. Now, although TDP still has presence in upper house through its lone MP, the party was deemed to have merged only for the purpose of not attracting penalty under 10th schedule for the four MPs who have defected. Now, the TDP too raised arguments similar to what BSP is now claiming, that a merger can take place only at an organizational level of the party, not in that house. Okay. Now, in 2016, 12 out of 15 TDP MLAs joined the ruling Telugu TRS party. Now, the speaker recognized this defection as a merger since more than two-thirds has moved. So these are some of the issues regarding merger. Okay, so if you have any doubts so far, please ask in the live chat session. Now I will give you 2 minutes to ask your doubts. After that, I will move on to the next topic of today, World Hepatitis Day. Okay. Okay, thank you, Kavikant. Now we will move on to the next topic of today. See, next topic of today deals with World Hepatitis Day. See, World Hepatitis Day is observed each year on 28th of July to enhance awareness of viral hepatitis day. Now, the theme of the year 2020 of World Hepatitis Day is Hepatitis Free Future. Now, this has a strong focus on preventing hepatitis B among mothers as well as newborns. Now, we will discuss different types of hepatitis that exists in India. Now, there are different types of viral hepatitis. Okay, now see here. See, what is an hepatitis? Hepatitis is an inflammation of liver. It's an inflammation of liver. What is the meaning of inflammation? Liver will expand. That is called as inflammation. Now, this will caused usually by means of viral infection. This will be caused usually by means of viral infection, but liver damage from alcohol consumption, or in rare cases autoimmune conditions also can cause inflammation. So this inflammation can be caused by means of viral infection, alcohol, or by means of autoimmune disorders. Now there are different types of viral hepatitis. One is A, B, C, D, E. So there are 5 types of viral hepatitis that can be found. Now if you look at the types of spread of different types of viral hepatitis, now if you look at hepatitis which are spread via food as well as water contamination, hepatitis A as well as E will spread via food as well as water contamination. Now types A and E usually don't require treatments. Now recovery time is 1 to 2 months. So if a person is being infected by A and E, they don't require treatment, they will be cured within 1 to 2 months. Now if hepatitis is spread via infected blood or bodily fluids, there hepatitis B as well as C. Now type B as well as C often require treatment to cure. Chronic cases can lead to cirrhosis as well as liver cancer. So they require treatment in the hospital, and some extreme cases can lead to cirrhosis. Cirrhosis means failure of liver or liver cancer. Now type D can infect only people with type B hepatitis. Okay. Now the vaccination is possible only for type A as well as B. Vaccination right now is possible only for type A and B. It is not available for E, C as well as D. Now, what are the key points regarding hepatitis? What are the key points regarding the infection, viral infection of hepatitis? See, the word hepatitis refers to any inflammation of the liver, the irritating or swelling of liver cells from any cause. So, if liver is inflamming for any cause, it will be called as hepatitis. Now, hepatitis can be acute. Clear? It can be okay. Now, Kavikant, you are asking the president's resignation, right? See here, if the president wants to resign, he will address his resignation letter to Vice President. He will address his resignation to Vice President of India and no other authority. Okay. Now, if it can be either acute or chronic. This infection can either be acute or chronic. Now, inflammation of liver that prevents with sickness, jaundice, fever or vomiting can be called as acute. Inflammation of liver that lasts more than 6 months but essentially showing no symptoms can be termed as chronic. That's what I said na, resignation. He will address his resignation letter to, he will give his resignation letter to Vice President of India. Now, Vice President of India immediately after getting the resignation. Here, if for example this is resignation letter, as soon as Vice President he receives his resignation letter, what he will do is that he will inform this resignation of President in Rajya Sabha, and he will also inform this resignation to Speaker of Lok Sabha. Now, why he informs both these houses is that because President is a part of both Lok Sabha as well as Rajya Sabha. Is it clear? President is a part of Parliament as well, so that's why as soon as Vice President receives a resignation, he will inform both Rajya Sabha and Speaker of Lok Sabha. So Speaker can inform Lok Sabha members of President's resignation. Now, if you look at how our uh, government has been set up. This is Lok Sabha, this is Rajya Sabha, and executive is taken out of both these houses of parliament, prime minister plus council of ministers. Okay, executive is taken out of both these houses of parliament, and there is president. Now this is executive, this is executive, president plus council of minister will be termed as union executive, and this is union legislature. So president is part of both executive as well as legislature, so that's why his resignation will be important, will be communicated to both the houses of parliament. Now what are the causes for hepatitis infection? What are the causes for hepatitis infection? Now hepatitis are usually caused by a group of viruses known as hepatotropic liver directed viruses, including A, B, C, D and E. Hepatotropic viruses including A, B, C and D. Now other viruses may also cause it, such as varicella virus that causes chickenpox, SARS-CoV-2 and the virus that causes COVID-19 may also injure liver. Now other causes including drugs and alcohol abuse, fat buildup of liver, fatty liver hepatitis, or autoimmune process in which a person's body makes antibodies that attack liver, autoimmune hepatitis. So if a person is infected via hepatitis, body will manufacture more antibodies that will attack liver. Now what is the treatment that is available to treat hepatitis? Now hepatitis A and E are self-limiting diseases. That means that it will go away on their own and they require no specific antiviral medications. But for hepatitis B as well as C, effective medications are available. Now if you look at the global scenario of hepatitis infections, hepatitis B and C together are the most common cause of deaths, with almost 1.3 million lives lost each year. In 2016, 194 governments across the globe accepted WHO's global strategy which aims at elimination of viral hepatitis by the year of 2030. Now if you look at Indian scenario, 40 million people are chronically infected with hepatitis B virus and 6 to 12 million with hepatitis C virus. In 2018, government launched National Virus Hepatitis Program. The program is the largest program for hepatitis B and C diagnosis and treatment in the world. Now note, hepatitis B is included under India's Universal Immunization Program, which provides free of cost vaccination against 11 vaccine preventable diseases, that is tuberculosis, diphtheria, pertussis, tetanus, polio, pneumonia, meningitis due to Haemophilus influenza type B virus, measles, rubella, Japanese encephalitis and rotavirus diarrhea. Now Bangladesh, Bhutan, Nepal and Thailand became first 4 countries in the World Health Organization Southeast Asia region to have successfully controlled hepatitis B. Now recently an automated coronavirus testing device known as Cobas 6800 was launched, which can also detect virus hepatitis B as well as C among others. Now it can be noted that only 4 diseases such as HIV, AIDS, TB, malaria and hepatitis have been officially designated with specific global awareness days by World Health Organization. So that's it everyone with regards to this topic. So okay, if you have any doubts regarding this topic, please ask in the comment section. If you have any doubts regarding this topic, you can ask in the comment section. Okay, so I will try to answer those. After that we will look at our last topic for today. I will give you 1 minute to ask your doubts everyone. Okay, since no one is asking any doubts, we will move on to the next topic. Okay. See, the next topic for today is International Thermonuclear Experimental Reactor. Now recently this
this International Thermonuclear Experimental Reactor celebrated the start of assembly of ITER Tomamark at Saint Paul les Durans in France. Now, what are the key points regarding this ITER reactor is that, see, this celebration was hosted virtually by French President, and all ITER member countries participated either in person or electronically through remote mode. Now, India also participated in these celebrations and considered the global participation of scientists to project as a perfect illustration of what is UNICEF. It's a body under United Nations which deals with children, which fights with child issues. Okay, child issues like improving education, improving health indicators for children. Yeah, that organization is there for children's benefits. Now, India believes that this project is a perfect collaboration of age-old belief of Vasudhaiva Kudumbam. Now, Vasudhaiva Kudumbam is a Sanskrit phrase which means world is one family. Now, what is the contribution of India for this ITR assembly? See here, India has also mentioned about its fair share in terms of its contribution for this ITR assembly. India has provided cryosat, cryogenic and cryo distribution systems, auxiliary heating devices, multi-megawatt power supplies, etc. Now, ITR cryosat is manufactured in India by L&T. Now, this cryosat is a chamber that can maintain extremely low temperatures. Now, it is the largest stainless steel steam high vacuum pressure chamber ever built by human. It has an area of almost 1600 meter cube, providing high vacuum ultra cool environment for ITR vacuum vessel and superconducting magnets. Now, the target for the first plasma to be achieved is during 2025. At extreme temperatures, electrons are separated from nuclei and glass becomes plasma, an ionized state of matter similar to gas. Now, European Union is responsible for largest portion of construction costs, that is almost 45.6%, and the remainder is shared equally by China, Japan, South Korea, Russia, including India, 9.1% by each countries. Oh, 10 minutes, 5 minutes, sorry. Now, if you look at nuclear reactions, there are different types of nuclear reactions. Nuclear reactions is nothing but it involves splitting or joining of two nuclei. Now, a nuclear reaction is a process in which two nuclei or nucleus and an extremely subatomic particle collide to produce one or more two nucleides. Now, thus, a nuclear reaction must cause a transformation of at least one another nucleide to another. So, there are two types of nuclear reactions. One is where one nuclei is splitting into two different nuclei called as nuclear fission, or when two nuclei combine to form a larger nuclei called as nuclear fusion. Now, in nuclear fission, a nucleus of atom splits into two daughter nuclei. This decay can be naturally spontaneous splitting by radioactive decay, or can occur by simulated lab environment by achieving necessary conditions to achieve criticality. Now, the resulting fragments tend to have a combined mass which is less than the original. The missing mass is usually converted to nuclear energy. Currently, all commercial nuclear reactors are based on nuclear fission. Now, if you look at nuclear fusion is defined as combining of two lighter nuclei to heavier one. Such nuclear fusion reactors are source of energy in sun and other stars. It takes considerable amount of energy to force two nuclei into one. Now, the conditions needed for this process are very extreme. Millions of degrees of temperature is required and millions of pascals of pressure is required. Now, the hydrogen bomb is based on thermonuclear fusion reaction. However, a nuclear bomb based on fission of uranium or plutonium is placed at the core of hydrogen bomb to provide the initial energy. Only then fusion can happen for hydrogen atoms. Now, if you look at the particulars of this ITER reactor, now this ITER reactor is a collaboration of 35 nations which was launched in 1985. Now, this reactor is located in France. Now, it aims to build world's largest tomamark to provide feasibility of fusion as a large scale and carbon free source of energy. Now, tomamark is an experimental machine designed to harness energy of fusion. Inside a tomamark, the energy produced through fusion of atoms is absorbed as heat in the walls of vessel. Like conventional power plant, a fusion power plant uses this heat to produce steam and then electricity by ways of turbines and generators. Now, applicable principle of nuclear fusion. This project is based on fusion, which is also an energy source of sun as well as stars. Every fusion reaction in the sun, in which two hydrogen atoms fuse into one helium atom, releases two neutrinos. Now, what is the significance of this assembly? See here, ITR will be the first fusion device to maintain fusions for a longer period of time. Also a test to integrate technologies, materials, physics regimes necessary for commercial production of fusion based electricity. Now if you look at the countries who are participating in this assembly, ITR member countries include China, European Union, India, Japan, South Korea, Russia and United States. According to ITR agreement, the above 7 members will share the cost of project construction, operation and decommissioning. They also share the experimental results and any intellectual property generated by the fabrication, construction and operation phases. Okay. Let's move into the class, move to the class today. Now these are the topics that we'll be looking today. The first topic is Consumer Protection Act of 2019. Now in this topic we will look at what are the provisions of this new amendment act which was introduced in 2019, and then we will compare the old act versus the new act. What are the differences between the old act and the new act? Okay. Now next topic we will look is display the country of origin must for e-commerce site. So in this topic we will look at what is the concept of certificate of origin. After that we will look at why it is difficult for e-commerce sites to display country of origin. Okay. Next we will look at the concept of plea bargaining. Now in this concept we will look at what is the concept of plea bargaining and what are the advantages of having plea bargaining and what are the disadvantages of plea bargaining. And next topic we will have a debate on which type of government is suitable for India. Next we will look at collaboration with Israel in with respect to foreign direct investment in defense sector, and then we will look at center's inability to pay GST dues and what are the reasons why center has been unable to pay GST dues. All these reasons we will look into this, and then we will look at merger under 10th schedule. So in this topic we will in depth look at what is 10th schedule, and then we will look at what are the provisions regarding merger under 10th schedule and what are the controversies related to merger under 10th schedule. And then we will look at World Hepatitis Day. With this topic we will look in depth on different types of hepatitis that are present in India, and lastly we will look at International Thermonuclear Experimental Reactor Assembly. So these are the topics that we will be looking today. So we are looking at 9 topics today. Okay, so this class will almost take around 2 hours to complete. So now let's jump right in. Give me a second here. Now, the first topic that we are discussing today is Consumer Protection Act of 2019. Now, why this topic was in news? See, the new Consumer Protection Act of 2019 came into force in 20th of July 2020, and this act will empower consumers and help consumers in protecting their rights through various notified rules and provisions. So, under Consumer Protection Act, central government is empowered to notify certain rules and regulation. Now based on these rules and regulations, consumers are expected to get their rights protected in a better manner under Consumer Protection Act of 2019. Now this new act of Consumer Protection Act in 2019 will be a swift and less time consuming compared to older Consumer Act of 1986. Okay, so if we compare this Consumer Protection Act with the older Consumer Protection Act of 1986, This new one will be very swift, that is, it will take a lot less time to dispose a particular consumer protection case. Okay. Now the swift access to the justice is given by means of having single point access to justice, making it a time consuming exercise. Now in old Consumer Protection Act, almost all consumer protection was taken by a single point of access to justice. What happens if there is only single point of access to justice? A lot of cases will get dumped in this particular code. Because of this lot of dumping of cases in a single code, what will happen? Courts will be unable to resolve these complaints very quickly. So that's a major issue with the old process. Now, the old act provided for three-tier consumer dispute redressal machinery at National Consumer Disputes Redressal Commission, state and district level. So it had, see, sorry for that. Now, old Consumer Protection Act of 1986 had a three-tier dispersal of justice for consumer protection. It had tribunals in national level, state level, and district level. So this is called as three-tier administration of justice. Now, the consumer, what are the key points regarding this new act? Now, this Consumer Protection Act of 2019 establishes Central Consumer Protection Authority, whose primary objective will be to promote, protect, and enforce rights of consumers. Now, this act empowers to conduct investigations into violations of consumer rights and institute complaints and prosecution, order recall of unsafe goods and services, order discontinuance of unfair trade practices and misleading advertisements, and impose penalties on manufacturers, endorsers, and publishers of misleading advertisements. So these are the things that this act is empowered to do so. Now, apart from all these things, this act also has certain rules on e-commerce and unfair trade practices. Now, the government will notify the Consumer Protection E-commerce Rules 2020 under this act, whose broad provisions are given below. So, under this act, under this Consumer Protection Act of 2019, central government is empowered to notify e-commerce rules. Okay. E-commerce rules 2020. Now, under the act, this e-commerce rules has been notified by central government. Now, this rules broad provisions include, the first one, e-commerce entities are required to provide information to consumers regarding information relating to return. So, if a person is purchasing an item from Amazon, Amazon has to list what is the return time frame period. So if they are purchasing a particular item, Amazon has to list within which amount of time I have to return a defective product, 10 days or 30 days, something like that. And then they have to give information regarding refund, how many days it will take for processing a refund, and then details regarding exchange, warranty, guarantee, delivery, shipment, and then modes of payment, grievance redressal mechanism, payment methods, security of payment methods, chargeback options, and then country of origin. So these are the information that e-commerce sites are supposed to list in their website whenever the consumer is purchasing items from their website. Good evening. I can't pronounce your name, sorry for that. These are necessary for enabling consumer to make informed decisions at pre-purchase stage. Now, these e-commerce rules for consumer protection are very important for consumer, because consumer is blindly trusting the seller because he doesn't physically see the product. Without even physically seeing the product, he is purchasing those products. So consumer should have some little bit of trust on the product. Now, to gain this trust, this information is very important to be displayed by e-commerce companies. Now, these e-commerce platforms will have to acknowledge the receipt of any consumer complaint within 48 hours, and they have to redress the complaint within 1 month from the date of receipt. Now, these e-commerce companies also have to appoint grievance officer for consumer grievance redressal. So, okay. Now, if I am purchasing a mobile phone from Amazon, clear? I am this person here. I am purchasing mobile from Amazon. Now I have a problem with this mobile, so I am filing a complaint to Amazon. Yeah, this is called as grievance. Okay. Now, upon receipt of this grievance, Amazon has to acknowledge my grievance within 48 hours, and they have to resolve my grievance within 1 month. Okay, so that's what they have mentioned in this particular point here. And apart from that, consumer protection rules are mandatory and are not advisory. So all these provisions are mandatory for e-commerce websites. Now sellers cannot refuse to take back goods or withdraw services or refuse refunds if such goods or services are defective, deficient, delivered rate, or if they do not meet the description on the platform. Okay, so if all these are not satisfied by the seller is bound to accept the refund. Okay, they have to make a refund, or they cannot say that I'm not giving you a refund even though this product is defective or delivered late or whatnot. And so this is very important for consumers on gaining trust in within e-commerce websites. Now, these e-commerce rules also prohibit e-commerce companies from manipulating the price of goods or services to gain unreasonable profit through unjustified prices. See, there are certain times where the demand for a particular product will be very high. So now, during the time, e-commerce websites are prohibited what to say, ungainly increasing the prices of a particular good so that they can gain unreasonable profit through unjustified prices. So these are the rules regarding e-commerce sites. Now let's take a look at the next important provision under e-commerce sites. Sorry, no, next important provision under Consumer Protection Act. See, a manufacturer or product service provider or product seller will be held responsible to compensate for inquiry or damage caused by defective product for or deficiency in services. Now, what are the basis for product liability action? Okay, what are the bases based on which a buyer can return a particular product? One is manufacturing defect, the next one is design defect, deviation from manufacturing specifications, not conforming to express warranty, failing to contain adequate instructions for correct use, service provided faulty or imperfect or deficient product. Now, all these form the basis of product liability action. Okay, so for example, because of this, if a consumer has been cheated upon, consumer can directly approach consumer court and file a complaint against this particular product against a particular company. So that's what they are trying to mention here. Now, what are the punishment for manufacture or sale of adulterated or spurious goods? What is the meaning of adulterated or spurious goods? Meaning, what is the meaning of adulterated fake goods? Fake goods. What are the punishment regarding sale of fake goods? In case of first conviction, a competent court may suspend any license issued to that person for a period of up to 2 years, and in case of second or subsequent conviction, it may lead to cancellation of their license permanently. Okay. Now the next, this is the most important thing. Consumer Protection Act of 2019 provides for alternate dispute mechanism of mediation. Now I'll explain this. What is this alternate dispute resolution mechanism? See here, if for example I am receiving a product from Amazon. From Amazon, I am receiving a product. Now this product, clear, the product sold to me by Amazon is fake. Clear, the product sold by Amazon by me is fake. Now what can I do? Now myself, I will go to Consumer Protection Court and file a complaint against Amazon in Consumer Protection Court. Now, in Consumer Protection Act of 1986, this was the only remedial measure. This was the only remedial measure based on which a person can get compensation, only by filing complaint in Consumer Protection Court. But in this new act, this person A, even before approaching Consumer Protection Court, he can enter into mediation directly with Amazon. What is the meaning of mediation? Mediation will happen out of court, and these will be settled mutually between two parties. Is it clear? Mediation will happen outside of court. This will be settled mutually between two parties. Now whatever happens in mediation, it will be enforced by both the parties, and both the parties will not what is it, they will not review this mediation in higher courts. Okay. So that's a provision in Consumer Protection Act of 2019. Okay. A complaint will be referred by Consumer Commission for mediation wherever scope of early settlement exists and parties agree for it. So if both parties are agreeing for mediation, this a particular complaint will be sent to mediation. Now the mediation will be held in mediation cells, which will be established under the aegis of Consumer Commissions. There will be no appeal against the settlement through mediation. Next one is simplification of consumer dispute adjudication process. Now, this act empowers the state and district commissions to review their own orders, enabling a consumer to file complaints electronically and in consumer commissions that have jurisdiction over the place of his residence. Okay. Also, video conferencing for hearing and deemed admissibility of complaints if the question of admissibility is not decided within the specified period of 21 days. And now, what are the other rules and regulations that have been notified by central government under Consumer Protection Act of 2019? As per this notification and rules, Consumer Disputes Redressal Commission rules, there will be no fee for filing of cases up to 5 lakh. So, if a particular case deals with a complaint up to 5 lakh rupees, there won't be any fee for filing that particular case. Now the credit of the amount due to unidentifiable consumers will go to Consumer Welfare Fund, also called as CWF. Now state commissions will furnish information to central government on a quarterly basis on vacancies, disposal, the pendency of cases and other matters. All this information will be communicated to central government by state government on a quarterly basis. Now apart from these general rules, there are Central Consumer Protection Council rules provided for constitution of the Central Consumer Protection Council. Clear? This Central Consumer Protection Council will be established for regulating consumer disputes. Now, this body will be an advisory body on consumer issues headed by Union Ministry of Consumer Affairs, Food and Public Distribution, with the Ministry of State as vice chairperson and 34 other members from different fields. Now, this particular body will have 3-year tenure and will have minister in charge of consumer affairs from 2 states from each region: North, South, East, West, and a Northeast region. Okay? Now, these are the differences between Consumer Protection Act of 1986 and the new Act. Now, if you look at the regulator in the old Act, there was no separate regulator under the old Act, but in the new Act, we have created a new type of regulator called a Central Consumer Protection Authority, which is to be formed under this new Act. Now, the rules regarding consumer court: complaint could be filed in a consumer court where the seller's office is located. Okay, so if I am filing a complaint against Amazon, I can file complaint against Amazon only in place where Amazon is located. But in case of the new Act, a complaint can be filed in a consumer court where the complainant resides or works. So even if I'm located, for example, if I'm located in Hindupur, it's a town in Andhra Pradesh, clear, I can file a case in Hindupur itself. I need not go to Bangalore or Delhi or whatever place where this particular company locates and file a complaint there. I can file a complaint in Hindupur itself. Next one is product liability. No provision for product liability is given in the old Act. Consumer could approach a civil court but not a consumer court in case of product liability. Now, in case of the new Act, consumer can seek compensation for harm caused by a product or service directly in the Consumer Protection Code. Now, pecuniary jurisdiction. What are the provisions regarding? Now, district courts can charge fines up to 20 lakh rupees. State consumer protection courts can charge fines up to 20 lakh to 1 crore rupees. National courts can give judgments for amounts above 1 crore rupees. But in case of the new Act, district courts can give judgments for fines up to 1 crore rupees, state courts from 1 crore to 10 crores, and national courts from above 10 crores. Now, what are the provisions regarding e-commerce? There are no provisions in the old Consumer Act for e-commerce industries. Now, all rules of direct selling are extended to e-commerce under the new regulation. Now, what are the provisions regarding mediation cells? There was no legal provision for mediation cells under the old Act, but under the new Act, court can refer settlement through mediation. Now, that's it with regards to this topic, everyone. Now, if you have any doubts so far, please ask your doubts in the live chat session. I'll give you 1 minute to ask those doubts. After that, I will move on to the next topic. People, if you have any doubts, please ask. Sandeep, hello Sandeep, welcome to the class. I hope you had a wonderful day. Now, since no one has asked any sorts of doubts, I will move on to the next topic for today. Now, the next topic for today deals with display of country of origin is must for e-commerce site. Now, what is this country of origin? Clear? See here. Uh, in globalized world, what happens? In globalized world, what happens? uh, if a cell phone has to be manufactured, getting manufactured, what will happen? The parts for this cell phone are sourced from number of different countries. Even if the cell phone is being assembled in India, now this cell phone company will source their products from number of countries like Japan, China, Vietnam, Norway, all these different, from all these different countries this cell phone company will source their products. Now, what this certain country of origin certificate means is that whenever a product is being sold in e-commerce sites, now that e-commerce site must display country of origin, from which country this particular product is originating from. So that's this concept of country of origin. Now, recently the central government has told via an affidavit in the Delhi High Court that e-commerce entities will have to ensure that mandatory declaration of country of origin of imported products sold on their site is compulsory. Now, the Consumer Protection Act of 2019 also mandates to display the country of origin by the e-commerce entities. Clear? Not only the court has directed the e-commerce websites to display the country of origin, but they have also been mandated by what is the Consumer Protection Act of 2019 to display country of origin. Okay. Now, what are the key points regarding this issue? Now, the affidavit came in response to public interest litigation, which seeks directions to the center to ensure that name of the manufacturing country is being displayed on products that are being sold on e-commerce websites. Now, the petitioner also has sought for the implementation of Legal Meteorology Act 2009 and Legal Meteorology Packed Commodities Rules 2011, which made that country of origin must be displayed on products being sold on e-commerce sites. See, whenever you are buying a product, doesn't mean whatever product that you are buying from a particular place, in every product they will display made in China, made in Vietnam, made in USA. Now, all these display of country of origin is mandatory based on these rules. Now, this petitioner who has filed a complaint in Delhi High Court argued that based on these rules, e-commerce websites are also empowered. They are also mandated to display country of origin in their website itself, not on the product. Now, the enforcement of the provisions of the said Act and rules rest with states and union territory governments. So, the enforcement of these rules rest with either state government or union territories. Now, the petitioner also has contended that the enforcement of the mandate is in sync with the recent vocal for vocal and Atmanirbhar Bharat push by Government of India. Yeah, earlier central government has also mandated for all sellers and government e-marketplace to list the country of origin while registering new products. Now, government e-marketplace is a platform for public procurement. So, if public work departments of Tamil Nadu government is constructing a road, they can purchase products from government e-marketplace. Right? So, it is an e-marketplace for purchasing products for public procurement. Now, what are the issues involved in this displaying of country of origin? See, most of the e-commerce sites function as market-based e-commerce model in which they only act as an intermediary. See, if you look at Amazon, Amazon directly doesn't sell many of the products themselves. So, for example, most of the third-party companies, like for example, Cloudtail India Limited, they are independent companies. They will sell their products using Amazon platform. Amazon will act as only intermediary for a particular seller and then buyer. So that is, they merely provide their information technology platform to connect third party sellers with their potential consumers. Now, to other e-commerce model is inventory based, where entities offer services or goods for sale from their own inventory. Yeah. Other form of e-commerce, inventory based. What is the meaning of inventory based? Like for example, mm, Basic. Basic is a clothing brand. Now, Basic clothing brand, they has their own website. Now, in their own website, they are selling products. They're selling products based on their own inventory, not based on third party. So this is called as inventory based e-commerce platform. Now, e-commerce entity says that they have ensured that data filed pertaining to a country of origin is available on their system, which may be filed in a seller, which may be filed in by a seller when creating a new product listing. Is it clear? However, they have not made it mandatory because the law does not mandate disclosure of country of origin, manufacture, assembly in case of India manufactured goods. In many cases, finished goods sourced from different countries are packed together or assembled in third country prior to their shipment into India. Therefore, it could not be presumed that rules intended that at least that the last country of export allowed to be declared as country of origin unless the law is amended or clarified to expressly state so. So these are some of the issues concerning displaying of country of origin in e-commerce uh, products. Now give me a second here. Now the next topic that we will be looking today is plea bargaining. Now what is this concept of plea bargaining? Now why this was in news? Because several citizens of various countries who were accused of violating visa conditions and government guidelines following the COVID-19 pandemic have obtained release from court cases in recent days by means of plea bargaining. Now what is this concept of plea bargaining that is recently emerging in India? Now to this concept further, I'll give you an example. See here, I'll give you an example. Now this person A. This person A has committed murder. Yes, committed murder. Now this person A is arrested by the police. Now police they are producing this person A before court. So after police producing this person A into court, what will happen? In court there will be a court case between state of Tamil Nadu. For example, if this murder was committed in Tamil Nadu, in this court case, this particular case will be conducted between state of Tamil Nadu and the defendant. So not the defendant, the accused A. Clear? So in court, it is on the burden of state of Tamil Nadu to provide evidence saying that this person A has been committed murder. The state has to provide sufficient evidence to the court, and they have to convince the court that this person A has been committed murder. Now, in some cases, state of Tamil Nadu will not have sufficient evidence. That is, police will not have sufficient evidence to prosecute a particular individual. Now, in that case, what will happen is that state of Tamil Nadu will enter into plea bargain with accused A. Clear? State of Tamil Nadu will ask A to accept that he has committed this crime, that is murder, so that the sentence for this particular person A can be reduced. Yeah, this is called as plea bargaining, where a state prosecutor will enter into an agreement with the accused so that their conviction will be reduced. Now, what is the advantage of this? If both these persons are entering into a plea bargaining, the number of case timing to time taken to resolve a particular case will be reduced. Not only that, most of the people who don't have sufficient evidence, like for example, almost 40% of jail population are under trials. Under trials. What is the meaning of under trials? People who don't have the money to pay bails, but they are still lodged in jails because they are charged with a particular crime. Since 40% of the prison population are under trials, by entering into plea bargaining, the amount of people who are under trials can be greatly reduced. So these are the advantages of having plea bargaining. So that's what they are trying to explain here. What are the key points regarding plea bargaining? It refers to a person charged with criminal offense negotiating the prosecution for a lesser punishment than what is provided in law by pleading guilty to a less serious offense. Now, it primarily involves pre-trial negotiations between the accused and the prosecutors. It may involve bargaining on the charge or in quantum of sentence. Okay. Now, what are the provisions regarding plea bargaining in India? The first one is pleading guilty. Now, there has been always a provision in CRPC for an accused to plead guilty instead of claiming the right to full trial, but it is not the same as plea bargaining. Plea bargaining is different from pleading guilty in the court. Now, in plea bargaining, this was introduced in 2006 as a part of amendments to CRPC as Chapter 21A containing section 265A to 265L. Now, cases for plea bargaining is allowed or limited. Now, what are the cases in which plea bargaining are allowed? Only someone who has been charged for an offense that does not attract the death sentence, life sentence or prison term above 7 years can make use of scheme under Chapter 21A. It is also applicable to private complaints of which a criminal court has taken cognizance. Clear? So, for crimes only less than 7 years and a crime where a court has taken cognizance of that crime, only for those crimes plea bargaining can happen, for not all the other cases. Other categories of cases that cannot be disposed of through plea bargaining are those that involve offences affecting the socio-economic conditions of the country or committed against woman or child below the age of 14. Clear? Now, what is the procedure for plea bargaining in India? Now, the plea bargaining process can be initiated only by the accused. Here, only the person A accused can initiate the plea bargaining. Now, this provision is different from the one in other countries like USA, where the prosecutor plays a key role in bargaining with the suspected offender. Now, the accused will have to apply to the court for invoking the benefit of bargaining. Thereafter, the court may permit the prosecutor, the investigating officer and the victim to hold a meeting for a satisfactory disposition of the case. Clear? Now, once a mutual satisfaction is reached by the prosecutor and the accused, the court formalizes the agreement by the way of a report signed by all the parties and the presiding officer. Clear? So, a person A and the prosecutor will commit an agreement called as plea bargain. Now, this plea bargain will be formalized in the court, signed by all the parties, that is signed by A as well as prosecuting officer and then presiding officer of the particular court. So all these parties have to come together and then they have to sign a particular order so that the plea bargaining will be finalized. Now the accused may or may be sentenced to a prison term that is half the minimum period for a fixed for a offense. So for example, for committing murder, the minimum term is 7 years. By entering into a plea bargaining, this minimum term can reduce up to a maximum of half. So you'll be up to a maximum of 3.5 years. Prosecutor is able to reduce the sentence. Okay. If there is no minimum term prescribed, the sentence should run up to 1/4 of maximum sentence stipulated in law. Yeah. If there is no minimum term prescribed, for certain offences there is no minimum term prescribed. If there is no minimum terms prescribed, the sentence should run up to 1/4 of maximum sentence stipulated in law. So if the maximum sentence is 25 years, by means of plea bargaining, if accused is entering into plea bargain, he should serve jail sentence at least for 8 years. Now the outcome may also involve payment of compensation and other expenses to the victim by the accused. Clear? So if this person A, as I mentioned before, if this person A has committed murder, clear? Now if this person A is entering into a plea bargain with the prosecutor, he may also be liable to pay compensation to the victim. Now what are the arguments in favor of plea bargaining? Now give me a second here. Let me put my laptop into charge. Now, arguments in favor of plea bargaining in India. See, as per the Justice Malimat Committee on Reforms of Criminal Justice System, which was formed in 2000, this plea bargaining will ensure speedy trial, ends uncertainty over the outcome of criminal cases. It saves litigation cost and relieves the parties of anxiety. Yeah. If, as I mentioned before, what if a person A is entering into an agreement between the prosecutor need not fight a lengthy legal battle in the court saying that this person A is guilty of a particular crime. Okay, so the time will be reduced and also litigation cost. What is the meaning of litigation cost? This person A has to hire a lawyer and also the state has to hire a lawyer. So all these litigation cost can be reduced. Okay? And then it will also reduce the levels of anxiety for all the parties. Now it would have also a dramatic impact on conviction rates. Yeah. So right now conviction rate is very low. Yeah. So by means of having plea bargaining, the conviction rates can be improved. Now plea bargaining is common in the USA and has been very successful method of avoiding protracted and complicated trials. Now as a result, conviction rates are significantly high in countries like USA. Now prolonged imprisonment of under trials without any progress in the case for years and overcrowding of prisons are also other factors that may be cited in support of reducing pendency of cases and decongesting prisons through plea bargaining. Now it may help offenders make a fresh start in life. Now what are the arguments against plea bargaining? Now people who are pushed to plea bargain are those who do not have the wherewithal to arrange for bail. So people who cannot afford bail, or the persons who will be pushed to enter into plea bargain with the prosecutor, not so poor people will be invariably pushed to accept a plea bargain. Even courts are also particular about the voluntary nature of the exercise, as poverty, ignorance, and prosecution pressure should not lead someone pleading guilty of the offences that may not have been committed. Clear? So if plea bargaining is there, invariably persons who will enter into plea bargaining is are the persons who are in already in poverty, who are very ignorant, and then because of prosecution pressure, police will exert undue amount of pressure on a particular individual to enter into plea bargain, saying that they don't have, they will be definitely convicted, and they will put a lot of pressures on the individual to plead for a particular crime. Now, the judiciary in earlier verdicts, especially before the introduction of the process, have disapproved of bargaining with offenders and pointed out that lenient sentences could be considered as a part of circumstances of a case after a regular trial. Mere acceptance or admission of guilt should not be a ground for reduction of sentence. Just because a particular offender has accepted that I committed a particular crime should not be a ground where the punishment is reduced. That is not acceptable in India. That's what courts in earlier judgments have given. Further, it may hamper the victim's right to fair trial, involvement of coercion by the investigating agencies, and corruption in the process. Now, as I mentioned before, what happens in plea bargaining? The state of Tamil Nadu enters into an agreement with the accused A. So, what are the provisions? What guarantee can state give, saying that they are not forcing this accused person A into plea bargaining? In most of the cases, what will our police authorities do? They will force this accused A, saying that he has to accept this plea bargaining so that his sentence will be reduced. Now, some argue that plea bargaining is against Article 20, Clause 3 of Constitution, which provides immunity to an accused against self-incrimination. What is self-incrimination? What is this concept of self-incrimination? A person cannot be compelled to act as an witness against himself. A person will not be compelled to act as a witness against himself. So, if a person A has committed murder, police cannot pressure A, police cannot coerce A into giving evidence for his own conviction. Clear? So, if has some evidence there, police cannot coerce A into his own conviction. So, that is called as right to self-incrimination. Now, many people argue that plea bargaining goes against the principle of self-incrimination. Now, what is the way forward for plea bargaining? Now, to sum up, while plea bargaining itself is beneficial to accused and the victim of a crime, enough safeguards are required to be placed to stop possible abuse of this process. Plea bargaining is a pragmatic vision to overcome the crowded criminal courts and prisons, and a potential way to improve the litigation efficiency and rationalize judicial resources, infrastructure, and expenses. Yeah. So we have to put in certain safeguards so that the process of the various mandates under plea bargaining is not abused by the police officers as well as accused. Now, in the next topic, we will compare parliamentary form of government with a presidential form of government. See, before going on to the topic itself, let me give you some basics on parliamentary form of government and presidential form of government. See here, government is any body which has three functions under it. Government should have executive function, legislative function, and then judicial function. So all these functions are very essential for government. So a body having all these functions will be called as government. Now, in ancient days, this government was run by king. Clear? King had all these three functions: executive, legislative, and judiciary. Now, gradually, these powers were taken away from king under parliament in UK. Clear? So in UK, out of parliament only, all these three functions were derived: executive, legislature, as well as judiciary. So in UK, executive comes under parliament. It's a what is a executive is a body of parliament. Also, legislature is also a body of parliament, and judiciary is also will also come under the authority of parliament. Now, in USA, what they did was that instead of having parliamentary form of government, they separated all these different functions into different bodies: executive, legislature, and judiciary. So all these three bodies are kept separate by means of separation of power, by means of separation of power, and all these bodies derive their power from a written document called as constitution. Is that clear? So that's the difference between parliamentary form of government and presidential form of government. In parliamentary form of government, all three organs of government will come under parliament, but in case of presidential form of government, all three forms of government derive their power from constitution. Clear? So executive is headed by president. Now president is not a part of legislature, is not a part of legislature, but in case of parliamentary form of government, what is executive? Prime minister. Prime minister is a part of legislature. He comes from legislature. Look at Narendra Modi. Narendra Modi, even though he is the prime minister of India, he is a part of he is a member of Lok Sabha. Clear? Now, recently it has been suggested that India should adopt a presidential form of government instead of parliamentary style of democracy inherited from the British government. Now, these suggestions have been given in the backdrop of frequent elections and related administrative as well as financial burden owned by India. Parliamentary system of government. Now, there are in parliamentary form of government there are two executives. The nominal executive is the head of the state. Example, President of India, while the real executive is the Prime Minister, who is the head of the government. Now, in presidential form of government, as I mentioned before, president is both head of state as well as head of government. But in case of parliamentary form of government, head of government is prime minister, but head of state is either queen or president. Now, in such a system, the role of president or the monarch is primarily ceremonial, and the prime minister along with the cabinet wields effective power. Now, in parliamentary form of government, the role of the head of state is merely ceremonial, and the prime minister along with the cabinet wields only effective power. Countries with such a system include Germany, Italy, Japan, United Kingdom as well as Portugal. Now, the Constitution of India provides for parliamentary form of government both at the center as well as in the states. Articles 74 and 75 deal with parliamentary system of the government at union level, and Article 163 and 164 contains provisions with regards to the states, and executive is responsible to the legislature of its policy as well as acts. Now, in presidential form of government, there is only one executive, both for head of state as well as head of government. Now, in this system, president is both head of state as well as government. Example, USA and South Korea. Now, the executive is not responsible to the legislature for its policies and acts, and is constitutionally independent of legislature in respect of its term of office. Now, what are the key points with regards to arguments in favor of parliamentary system and arguments against parliamentary system? Now, what are the arguments against parliamentary system? One is unqualified legislators. Parliamentary system has created unqualified legislators who have sought election only in order to wield executive power. See here, in case of presidential form of government, what is happening? Executive is elected separately. People will elect only for president. Now, president will appoint his own cabinet based on expertise. Cabinet members, Secretary of State, Secretary of Defense, all these are executives under President. Now, all these people are appointed by President based on expertise, not based on election. So, but in case of India, clear, what are the people, who are people elected to? People are electing only for legislature, clear. Now, in legislature, based on a majority, they will elect executive themselves. Now, executives, now they may not have specialized knowledge on a particular department. Clear? Now, in presidential form of government, if president is appointed a particular person, president for secretary of state, he will appoint a person who is well versed in foreign affairs. Only then he will appoint a person. But in case of parliamentary form of government, people who are selected for minister post are members of parliament themselves. So there is no guarantee that This particular ministers, executive, have specialized knowledge on a particular subject. The next one is it limits the executive post to those who are electable rather than those who are able. Okay. So, for example, take the case of a number of diplomats, number of expert persons. Now, these expert persons are not in favor; they are not suitable for fighting elections. Yeah. In case of presidential form of government, these people's expertise can be used because president is a person who is appointing them. But in case of parliamentary form of government, those persons who are not willing to fight in elections, who are not eligible, not eligible, those who are not cut and right for elections will not fight in elections and they will not hold executive post. Example: Prime Minister cannot appoint a cabinet of his choice. He has to cater to the wishes of political leaders of several parties. Now, powerful executive, most of the laws are drafted by the executive and parliamentary input into their formulation and passage is very minimal. Is it clear? Even though parliament is the body where the legislation has to be passed, most of the legislations are drafted by the executive and the input of parliament is very less. Is it clear? In case of in case of presidential form of government, executive is not a part of legislature, so legislature, they themselves has to come up with the legislation and they have to pass that legislation. Is it clear? Legislature, they themselves have to pass a particular legislation, not the executive. So anyone, any member of Senate or Congress, they can pass legislation, not just the executive. Now, it has been seen that the ruling party issues whip to its member in order to ensure unimpeded passage of a bill. Since this defiance of a whip itself attracts disqualification, MP blindly votes as their party direct. Hence, parliamentary systems does not permit the existence of legislature distinct from executive. Clear? So, there is no separation of power between executive and legislature. Since there is a separation of power, most of the matters, most of the direction to legislature is given by the executive, not the other way around. Now, fickle legislative majority, it has forced the governments to concentrate less on the governing than staying in office and obliged them to cater their coalitions. It puts insurance on defections and horse trading. Now, the Anti-Defection Act of 1985 has failed to cure the problem since the bargaining has shifted to getting enough MLAs to resign to topple a government while promising them office when they win subsequent by-elections. Now, the next one is distorted voting preference. It has also distorted the voting preferences of an electorate that knows which individual it wants to vote, but not for the party. Now, what are the arguments in favor of presidential system? Stable executive. Clear? It establishes presidential system establishes a stable executive which does not depend on the fluctuating will of the legislature, especially in case of coalition governments. A system of directly elected chief executives at all levels, panchayat chiefs, town mayors, chief ministers, and national president elected for a fixed term of office, invulnerable to whims of legislature, and with clearly defined authority in their respective domains would permit India to deal more effectively with its critical economic as well as social challenges. And the ability over electability, cabinet posts would not be limited to those who are electable, but rather to those who are able to rule. Now, the president can appoint anyone as their secretaries, which is equivalent to that of minister. Now, effective check and balance, it establishes presidency and the legislature as two parallel structures. This allows each structure to monitor and check each other, hence preventing abuse of power. Next one is role of citizens. At the end of fixed period of time, public would be able to judge individuals' performance rather than on political skill at keeping government in office. Further, Indian voter will be able to vote directly for an individual he or she wants to be chosen as a head rather than majority of members of parliament and legislative assembly. Now, what are the arguments against the presidential form of government? The first one is lack of cooperation. A weakness of the system is its failure to ensure cooperation between lawmakers and administrators. See, in case of parliamentary form of government, executives come from legislature, so there is a cooperation between legislative arm of the government as well as executive. But in case of presidential form of government, there is no cooperation. You might have come across news in America saying that the government has shut down. Why? Because legislature is not willing to cooperate with executive. That's why executive will shut down the government. legislature will have majority of Democratic Party and executive will have Republican president. Now, in that case of difference of political parties, what will Democratic Congress do? They will not pass legislation which is in favor of Republican president. So, executive will immediately shut down the government. So, there is no cooperation between the lawmakers and the administrators of a particular country. Now, frequent conflicts between the legislature and executive may lead to deadlocks. And the presidential system of government centralizes power in one individual, unlike parliamentary system, where the prime minister is the first among equals. The surrender to authority to one individual, as in presidential system, is dangerous for democracy. Now, also concerns over separation of power. If the legislature is dominated by the same party to which president belongs, he may prevent any move from the legislature. Now, what are the benefits of parliamentary system? Parliamentary system ensures diverse representation. By looking at the diversity and number of parties from different states, India needs diverse cabinet to fulfill aspiration of the millions of people. Hence, the parliamentary system ensures regional representation by selecting candidates from different parts of the country. Now, also, it is part of the basic structure of the constitution. Parliamentary form of government is basic structure of the constitution. Altering the parliamentary system would face legal hurdles. And also, a parliamentary form of government prevents authoritarianism. Since the executive is responsible to the legislature and can vote it out of motion of no confidence, there is no authoritarianism. Also, unlike presidential system, power is not concentrated in one hand rather than a group of individuals, also called as council of ministers. And also, in parliamentary form of government, there is better coordination. Since executive is a part of legislature and generally the majority of the legislature support the government, it is easier to pass laws and to implement those laws in parliamentary form of government. And also, parliamentary form of government is a matured system. It's an old system and can give new ideas with its experience in a democratic setup. So these are the advantages of parliamentary form of government. Now, what is the way forward for India? Whether India should follow parliamentary form of government or presidential form of government? Now, we should ensure that system of government whose leaders can focus on guarantee rather than on staying in power. The present parliamentary system has been tried and tested for nearly 70 years. It can be reformed through thoroughly to remove any challenges thrown up by it. So rather than adopting new form of government, we should try to reform the existing form of government so that it can function better. Further, there is no need to reform the electoral process to make democracy more robust. The debate should be on various loopholes in the electoral process, that is, from limiting expenditure of political parties and deciding the ceiling on expenditure to holding simultaneous elections, declaring the results for combination of booths instead of constituencies, etc. So these are the things. Instead of opting for a new form of government itself, we have to refine our existing parliamentary form of government so that our government can become better in the future. Okay, so I finished this topic, everyone. If you have any doubts, please ask in the live chat session. I am not feeling well, so instead of completing all the topics, I am ending the session right now. Okay, I cannot continue further. I am not feeling well. Okay, so sorry for that. In next class, I will take remaining topics. Okay, there are some another 5 topics remaining. Okay, I will take these 5 topics in another class. I'm extremely sorry for that. Okay. If you have any doubts so far, please ask in the live chat session. I will give you 2 minutes for everyone to ask those doubts. If you're not asking doubts, I'll end this session. Okay, I will give you 2 minutes for everyone to ask your doubts. If you're not asking doubts, I will end this session.